Hello, friends. We are back with Chapter 5, Criminal Law and Procedure. And the last lecture, we talked about just the basics of criminal law. It was kind of a review of some things we had already talked about. Now we're going to talk about the limits on the power of government. Now, if you remember from Unit 1, what is it that limits our government? And it's the Constitution, right? And it's our Bill of Rights. Oh, goodness, update. It is our Bill of Rights and what's contained in them. And please keep in mind that criminal law, all of the Bill of Rights apply, particularly our freedom of speech, our due process, and our equal protection. And your book talks about them a little. But I want to talk specifically about some of the limits on the power of government that are specific more to criminal procedure. And one of the big ones is the Fourth Amendment, and that is what we're going to focus on: the search and seizure, probable cause, exceptions to warrant requirement, and expectation of privacy. So our Fourth Amendment is the right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, as you can see in here, there is going to be a lot of words that are pretty vague. And how do you think over time we know what they mean? Case law, right? The judges have told us in case decisions. So, one I want you to write down now is your second point that in this unit that you'll be asked on the quiz. And so the second point is the warrant requirement, which is in the Fourth Amendment. So just write the warrant requirement protects our reasonable expectation of privacy. So the warrant requirement protects our reasonable expectation of privacy. What's in that blue box there? And we're going to explain that, okay? So there was a case that came down. It's a famous criminal case called Katz v. United States. And it really said what our unreasonable searches and seizures meant. And that's where it came down and said, listen, it is unconstitutional to conduct a search and seizure without a warrant anywhere that a person has a reasonable expectation of privacy. So they took the unreasonable search and seizures and said that's what that means. If we have a reasonable expectation of privacy, get a warrant, okay? And a warrant then is going to have probable cause supported by other information and describes the place to be searched and persons or things to be seized. But where do we have a reasonable expectation of privacy? Well, first, it's the individual themselves have exhibited an actual subjective expectation of privacy, somewhere I feel like I should have privacy. And the second is the expectation is one that society is prepared to recognize as reasonable, okay? And Katz involved a phone booth, and whether or not when someone was talking, yep, this is how far back it was, a phone booth. In a phone booth, could the police, basically eavesdrop in the phone booth? And the Katz said no, they have a reasonable expectation of privacy of being on a phone call, and society would respect that. So you need to get a warrant in that case. So what Katz tells us is what is protected. Places, things where we believe, and the house is usually the one where we have the biggest expectation of privacy. The thing about the Katz case is you see after the reasonable expectation of privacy in red, comma, unless certain exceptions apply. What does that mean? It means you have to get a warrant unless certain exceptions apply. Now, through time, case law has said there are certain things that we're going to say you don't have to get a warrant for. One is if we have a lawful arrest of you, we have probable cause, and we'll talk about probable cause for arrest in a second, and we search and seize something incident to unlawful or to a lawful arrest. Vehicle searches. You can search a vehicle if you have a probable cause to believe there's contraband in that vehicle. inventory searches if you're doing inventory in a vehicle where the vehicle has been impounded. Consent. If you allow the police come in your house or you allow the police, let me give you a hint. If the police ask for consent, it's because they know they can't search it without a warrant. And you have the ability to say no. But if you say yes, then they don't have to get the warrant. Exigent circumstances, meaning maybe if they can prove that they were worried that there'd be destruction of evidence, you're going to flush that contraband down the toilet or something. And plain view searches, meaning if the officers are in a lawful position and they observe in their plain view contraband or evidence of a crime, they don't need to get a warrant for it because they just saw it if they were in the proper place. Okay, so let's talk about then if we don't have one of these exceptions and they need to go get a warrant. What it says is that no warrant shall issue but upon probable cause is our first thing. What does that mean? Well, what the law says is that if an officer has reasonable belief based on the circumstances, and we usually call it the totality of circumstances known to that officer that a crime has occurred or is about to occur, then they have probable cause. And they can use witness statements, other evidence, hearsay evidence even, because it's just using probable cause to make a warrant. It's not to, in a court of law, to try to convict you. It's to get a warrant. So even if there's evidence not admissible at trial, if you use that for the basis of your probable cause to get a warrant, it's okay. But it can't be based on just, oh, I have a hunch or I believe that maybe this person is, committing this crime in their house and I need to go in and look, or I need to go and search their phone because I believe there's evidence in there. That's not enough. What else it says is they have to make the oath or affirmation as to the truth on the matter supporting probable cause. So what they do is they write what we call an affidavit out that says this is our probable cause. They take it to what we call a detached magistrate, which is supposed to be basically a judge that saying, hey, this is my probable, that has no like bias, and this is my probable cause to support this. In that warrant, they have to say where they're searching and the person or thing to be seized. Now, this is what's really important. I want you guys to listen. If I have a warrant, I'm an officer to go into your house to look for something, and they said, we believe that we are going to go look for computers because we believe that there have been these computer crimes. They list out their probable cause. And what they say is we're going to search the home and seize any evidence where a computer crime. Okay. They cannot go into every single little crevice of your house. If they're looking for computers or evidence of a computer crime, and they go into an envelope that's sitting out inside your kitchen and they find illegal drugs, that is an illegal search or seizure because it's beyond the warrant requirement. You're not going to find evidence of the computer they're looking for, their computer crime in that envelope. Okay. They just went in and started snooping. Now they're going to maybe argue, hey, we're going to look in them because we think that there might have been receipts or something. But no, it has to specifically, because if it's too broad and the warrant doesn't identify specific items or persons, it's going to be invalid. It has to specifically, they don't get a free for all to go look in your house or whatever area they're going to search. So probable cause for an arrest, what is that? If the officers have facts and circumstances known by them and a reasonable person would believe that that suspect is committing or is attempting to commit a criminal offense, so facts and circumstances, a reasonable person, they have probable cause to arrest. You do not have to have an arrest warrant. Arrest warrants are used, generally speaking, when you're doing an investigation and then you're going to go arrest the person. But if you are in the process of tracking down someone who has just robbed a store, or someone who is drunk driving, or someone who has murdered someone, you can arrest that person right there if you have a reasonable person would believe based on the facts and circumstances that a crime has been committed. So you don't need an arrest warrant. Stop and frisk. There's a famous case called Terry v. Ohio, and it's called the Terry stop. Stop and frisk is even a lower level. We have reasonable suspicion. So reasonable suspicion is lower than probable cause. Probable cause is a little bit higher. And these are both lower than our other evidence standards in trial: preponderance of evidence, beyond reasonable doubt. An officer has reasonable suspicion. If they have it, reasonable suspicion that an individual is armed and dangerous, they can come and they can pat them down or frisk them. That is not illegal search and seizure, but it has to be limited to weapons and the outer clothing of the individual. If they find a weapon or something that they feel is a weapon, they can go in the pockets or whatever and retrieve it, okay? Even if it doesn't actually end up being a weapon. So let's say I'm an officer and I have reasonable suspicion, okay? And we're going to talk about what that means in a second, but reasonable suspicion that you may be armed and dangerous, and I'm talking to you, I can pat you down. And I feel something and I think, oh, that's a weapon. I can go in and pull it out. And if it's your sunglasses or your eyeglasses, that's okay, as long as I had reasonable suspicion, or I reasonably believe that was a weapon, okay? What I can't do, again, is go into pat you down, feel something that doesn't feel like a weapon, maybe an envelope or something, take it out, find that you have illegal drugs in it, and then charge you for that, because that is beyond the scope of a Terry stop, okay? A Terry stop says officer just has to have reasonable suspicion that you might have a weapon, and they're allowed to conduct it to seize weapons, objects that feel like a weapon, and objects that an officer can tell from the pat down are contraband, meaning that I can tell it's contraband by patting you down. Then that becomes plain view. We call it plain feel. So we extend that even more. But in my example, with an envelope that has contraband in it, unless you can really tell that's contraband, you can't just go look for through someone's pocket. The key to a Terry stop is to realize an officer frisk is less extensive than an actual search. Okay. So therefore, you don't need to have a warrant. Okay, so let's keep in mind a Terry stop is the officer is stopping and talking to you, maybe has reasonable suspicion a crime has occurred, so is talking to you. They want to frisk you. They can do that without a warrant as long as they have reasonable suspicion. They can't arrest you unless they have what? Probable cause. So let's remember that. Reasonable suspicion for a frisk, write that down, probable cause for an arrest. If you need a warrant, that's also probable cause, okay? And these are all different standards. Reasonable suspicion is less than probable cause. One of the areas that's very, very kind of come out lately is cell phones and how much can an officer go on your cell phone. Well, Riley v. California came down in 2014, and in that case, the defendant was arrested on weapons charges, and they had a smartphone that they pulled out of his pocket, and they noticed that there was information that implicated him in the street gang activity. Okay. 2 hours later, they had a specialist examine the contents of the phone and found evidence connected the defendant to a shooting that occurred several weeks earlier. And so what they used is to enhance his sentence in that. Here's the problem. They were okay when they grabbed his pant pocket, because once he was arrested, you can seize their evidence. You can seize what's on them as part of the arrest. They're okay. And what he noticed on the cell phone, let's say this is a cell phone, is plain view, right? What the problem was is they got in and examined the contents of the phone without a warrant. Okay. And that is where they crossed the line. The court said, we cannot deny our decision will impact the ability of law enforcement to combat crime. Privacy comes at a cost. And what they were saying is, listen, we know that them being able to come in this phone is really going to help them a lot, right? A lot. But privacy comes at a cost. And what they said is, our cell phones probably have more privacy in it than anything else we could have today. We hold so much information in there, and law enforcement cannot just go in there without a warrant. So keep that in mind. They can, incident to arrest, take the cell phone, right? but they cannot go in and view the contents without a warrant. And that warrant has to tell that judge why they have probable cause to believe in that cell phone there's specific evidence related to what they're investigating. Okay, if I pull you over for DUI and I grab your phone, I can't ask the judge for a warrant because I think that there's evidence of your DUI in that phone. No, that's just a fishing expedition. Okay, what it is they have to do the same thing they would for that warrant requirement we just talked about. Another case is United States versus Worry. And in that case, the defendant was arrested and he had one of those flip phones. And they noticed that when they saw the phone, they noticed that the phone was receiving calls from a place called My House. Okay. The police assessed the call log then. So they went in and they saw on the flip phone, they could see in plain view the phone number. But what they did is they went into the call log. And that information, they secured a warrant for an apartment where there was found drugs and they convicted them. And they said, you were fine seeing the phones calls come in. But where you crossed the line was going into the call log. And the Supreme Court was very firm in that and said, our answer to the question of what police must do before searching a cell phone seized instant to arrest is simple. Get a warrant. You can seize the phone, but you cannot go into that phone without a warrant. Okay. So these are very important cases because it has to deal with today and where we store our information and how important our information is. And that law had already been established for computers, and they extended it and said, listen, it's the same for a cell phone. You can't go in and start searching through someone's cell phone. So we're going to switch. There's a couple more constitutional rights that apply to criminal. One is the Fifth Amendment, okay? And it's self-incrimination, meaning what? You don't have to testify against yourself. Miranda warnings, we've all heard of those, right? We have a right not to make statements that are against our self-interest. But what about papers? What they say is our papers we have a Fifth Amendment right not to incriminate it. They cannot require us to hand over papers in a criminal case that incriminate us unless what? We're a corporation. If a corporation in the regular process of business keeps certain papers and the government wants to seize those papers and get a warrant, they can, because corporations are not protected from the self-incrimination of the papers that it keeps. Okay, that's different from people, and it's very important to know. If those papers are in the control of a record keeper, they have to disclose those, even if they include incriminated evidence, because the corporation's paperwork is not protected from the Fifth Amendment. So what do we mean by this evidence suppression, fruit of the poisonous tree? I'm going to talk about that in 1 second because it applies to all of the rights if they're violated in a criminal case. Sixth Amendment, we have a speedy trial right, trial by jury, and we have assistance of counsel. So if any of our rights are violated, what happens? Well, a common thing is someone goes, well, my case gets thrown out. They didn't read me my Miranda warnings. My case gets thrown out. Not really. We call it the fruit of the poisonous tree. And what that means, and the exclusionary rule, is any evidence that they seized illegally is thrown out. They cannot use that specific evidence. And if they got evidence, and if that evidence led to additional evidence, they can't use that either. So what that means, if they went into my phone and they didn't have a warrant, and they said, oh, I have the address of this location, such as the other case, and they go and get a warrant based on that, that warrant was based on poisonous evidence. So that warrant for that evidence they found at the house and any evidence they found inside my phone will be excluded from trial, which makes the government's ability to make their case a little bit more difficult in some circumstances. And what this is to deter police officers from doing illegal searches and seizures. So that's what we call the fruit of the poisonous tree. If they did an illegal search on your phone and they didn't get any incriminating evidence, there's no real remedy because the remedy would be they can't use the evidence and there's no incriminating evidence. So it just depends on what evidence is there and what is and how it's excluded. So that is the remedy for any of the illegal uh, unlawful searches or seizures or failure to read us our Miranda rights or any of the other amendment or constitutional issues. So, constitutional protections and the corporations. I would like you to make sure you watch the video Citizens United versus CEC because it talks a little bit about the First Amendment constitutional right of corporations. If you have any questions, please contact me. We are going to talk about white collar crimes next.